Mr. Speaker, I yield myself such time as I may consume.
The gentleman from California is recognized.
Mr. Speaker, I rise to express my support for H.R. 2334, the Service Member Residence Protection Act as amended. However, I still have many concerns that the bill, while well-intentioned, does not live up to the promises made by some supporters. I appreciate the work of the majority to improve this bill during our markup. All of us want to ensure that service members do not return home from serving their country to find trespassers or squatters living in their homes. We also want to ensure that service members who are confronted with this situation have the tools and the resources to seek legal relief. However, I want to be clear that neither the original bill nor the amended text we are considering today will eliminate the possibility that a service member will need to seek judicial or other legal relief to evict a trespasser. The ability of Congress to legislate a solution to that particular issue is legally difficult. The text of H.R. 2334, based on my amendment in committee, was drafted so as to avoid creating confusion where courts have already ruled in Service Members Civil Relief Act cases involving adverse possession by codifying existing legal interpretations of SCRA tolling provisions. Now, what that means is that in many state courts across the country, they've already found that the SCRA applied to adverse possession, and in that period of time, while a service member was away from their property, did not count toward adverse possession. The amended bill simply makes this existing legal interpretation law. Because acquiring title to property through adverse possession is a long and involved process, in practice, this legislation would likely apply to service members in rare circumstances, such as when an adverse possessor was able to satisfy all of the elements of adverse possession, including possession for the lengthy statutory period, which is likely longer than most service members are stationed away from home. Now, the other type of trespassing case a service member may encounter is a holdover tenant, such as may happen if a service member rents out their property while they are away from home. Now, many of the stories presented to the committee to support this bill were of that type of trespass. A service member invited someone to stay at their property while they were gone, and then the tenant did not want to leave. It is important to follow good practices when becoming a landlord, such as using a written legal lease agreement, and this legislation does provide instruction for the Department of Veterans Affairs to work with the Department of Justice to provide resources on landlord-tenant practices and securing vacant property. However, nothing in this bill removes the requirement that someone seeking an eviction will need to follow a legal process to do so, which may include seeking assistance from law enforcement or going to local courts. Evicting someone from property requires due process. In addition, the SCRA is not self-enforcing. A service member must seek to enforce all of its protections through a legal process. Ultimately, service members will need to seek legal assistance to deal with trespassing cases. And we owe it to service members to provide them with the information and resources to navigate that process. This legislation, unfortunately, does not bolster access to legal assistance, but I hope the sponsors of this legislation will join us on those efforts in the future. I will be supporting this legislation today, as it does make some improvements for those service members who find themselves in the rare occurrence of adverse possession, and I hope we can do more in the future. But I don't want to give the service member and service members the false impression that this bill will immediately solve the trespassing issues presented to the committee. I urge my colleagues in the House and the Senate as well to support this bill, and I reserve the balance of my time.